Okay, Larry, thank you. The floor's yours.
Okay. Greetings, everybody. I'm Larry Schnapf. I'm one of the attorneys representing the Mary Farrell Foundation in our lawsuit against the President Biden and the National Archives. We have sued the President and the National Archives for failing to comply with the President John F. Kennedy Assassination Records Act, and because they haven't released all the records, and the records that they have not released, it's our belief that they have withheld them in violation of the statute. So I'm going to spend some time discussing the lawsuit and where we are and where we're going. But first, I want to begin about how we got to this point of having the John F. Kennedy records classified. So I'm going to go through some slides. These are historical in nature, and I'm going to go through them quickly because I don't want to take up a lot of time. I want to go focus on the lawsuit, but you'll have the slides for you to take a look at your leisure. Now, the president, we have three branches in our government: the president, the legislature, and the judiciary. The legislature passes laws, the president executes them, and then the judiciary determines if they've been lawful or if they're being administered properly. The president, as commander-in-chief, has some inherent rights when it comes to national security, and then the Congress can also add to those authorities by way of statute. So up until 1940, actually, classified records were handled by the military. The president had no role, or at least had asserted no role. And that started with President Roosevelt. And then there was a National Security Act passed in 1947 that allowed for a reorganization of our military, plus the creation of the National Security Council and the CIA. And President Truman started a practice of issuing orders discussing what kinds of records can be classified and who may classify them. So this is just a quick example of some of the executive orders. President Truman issued one, Eisenhower, and initially the records could be withheld up to 50 years. In 1972, Nixon changed it so that 30 years was the default. They could be declassified earlier with some exceptions. And then President Carter issued an order that broadened or liberalized how records could be unclassified. President Reagan went backwards and once again tightened up the rules. And it was President Reagan's executive order that was in effect when the John F. Kennedy Assassination Records Collection Act was passed. The Warren Commission actually was not authorized to classify their own records. They were not given the original classification authority. Nevertheless, the General Counsel of the Warren Commission instructed the court reporters that were taking down the testimony to mark them top secret or confidential. And so the Warren Commission records were improperly classified. Now, in 1965, President Johnson became aware of this, and there was an effort by the Department of Justice to create guidelines for having public availability to some materials of the Warren Commission. And you'll just see this is just a chronology of how we got to where we did, where a good bunch of the records were still withheld through the early 70s, and the only way that they were getting released was through lawsuits under the Freedom of Information Act. And Harold Weisberg was famous for this, but there was a couple of exceptions in the Freedom of Information Act that was being used by the government to withhold the release of the records. One was the first exception, which was records that are specifically required to be kept secret by pursuant to an executive order, which are those we just talked about. And then the seventh exception was for investigatory files compiled by law enforcement, to the extent, well, they were for supposedly active law enforcement matters. And the FBI kept using this seventh exception for pushing back on releasing any of its JFK records, assassination records, which was odd since that was only really an exception for active investigations. And of course, Congress exempted themselves from the Freedom of Information Act, so people could not file Freedom of Information Act requests to get the records from the House Select Assassinations Committee or the Church Committee. Beginning in the early 70s, we had a couple of congressional hearings on this issue. And the most notable one was the one from November 11th, 1975, which is Bella Abzug's hearing. And this is the cover sheet to that hearing. And this is a letter as part of the research done or investigation done by the committee. They determined that the Warren Commission was not authorized under the executive orders in effect to classify their records. And in fact, David Bellin, who testified at this hearing, acknowledged that they did not have the authority. They should not have been able to classify the Warren Commission files because they themselves, the staff, were not read in. They didn't have the authority to review classified records, amongst others. So then the House Assassinations Committee, when they completed their work, those records were subject to the House rule of House Rule 36, which required unpublished House records that were 30 years old or less were unavailable for public inspection, and that records more than 30 years old could be made available upon the express written consent of the clerk. So even the House Select Assassination Committee records were not available. So that was sort of the state of play when the Oliver Stone's movie came out and prompted the passage of the JFK Records Act. So JFK Records Act has a series of findings, and you'll see that number 4, well, first of all, number 3 says that we need legislation was required because we needed an enforceable, independent, and accountable process for public disclosure of records. That the legislative records, number 4, wouldn't be released until 2029, which in 1992 was a long time away. And that the legislation was also necessary because the way the Freedom of Information Act was being used, it was preventing the timely public disclosure of records. Likewise, the way the executive order that was in effect at the time was being administered, it too was preventing records from being disclosed in a timely manner. And of course, the records were 30 years old, and Congress felt that only in the rarest cases there was any legitimate need. So that was what Congress intended. Now, the battle that we've had in our lawsuit is over what are the requirements that the president must comply with in order to postpone records. And the key section of the statute that we're battling over is Section 5G 2D. And so this is called Periodic Review of Postponed Assassination Records. You'll notice that the first paragraph says all postponed or redacted records shall be reviewed periodically. And then 2B says all postponed records that are determined to require continued postponement shall require an unclassified written description. And D is each assassination record shall be publicly disclosed in full, unless after 25 years, the president certifies that the continued postponement is necessary because of an identifiable harm to the military, defense, intelligence operations, law enforcement, or conduct of foreign affairs, and the identifiable harm is of such gravity that outweighs the public interest. So we've been arguing that each record, he has to make this finding for each record. What the President Trump and President Biden have been doing is making a certification on just all the group of records, saying that, I certify that the agencies have requested X amount of records to be withheld, and I am certifying that this complies with the act. He doesn't go through, neither President Trump nor President Biden have gone through each of the records and said, this is the identifiable harm posed by this record, and here's how it outweighs, it's of such gravity it outweighs the public interest. So this is section 5G, 5G2D. That's where the heart of the lawsuit is at. Now, we also argue that section 6 applies. Section 6 is grounds for postponement for disclosure of records. And it says that disclosure of assassination records or particular information may be postponed if there is clear and convincing evidence. And then it goes through the following categories. Now, these categories, the 1, 2, 3, 4, 5, and 6, 5, they're very similar to the categories in 5G2D. They have subsections, which we call subcategories, and the government has been arguing that section 6 is no longer in effect, that on October 26th, 2017, 25 years after the statute was passed, that section 6 went away, and that the only relative section is the one we went previously over on 5G2D. The reason that section 6 is important because it requires a clear and convincing evidence, and you'll see that part of the subcategories include individuals. So individual agent whose current identity requires protection, an intelligence source, a method utilized currently or reasonably expected to be utilized in the future that would interfere with the conduct of intelligence activities. Any other matter relating to military defense, intelligence operations, foreign relations, disclosure which would demonstrably impair the national security. So they have to make, this statute requires a clear and convincing evidence, which is a criminal standard. In other words, think about beyond a reasonable doubt. It's a very high standard. And we have argued that the president, in both presidents, but we've only sued Biden because he's president. If you sue a prior president, there's no power he could have to do anything. So we sued Biden. That Biden, when he made the postponements, he did not demonstrate the clear and convincing evidence. These are the other grounds. Now you'll see that number 2 is key also, because it says the public disclosure that will reveal the name or identity of a living person who provided confidential information in the United States, and that this disclosure would pose substantial risk of harm to the person. What the government has been doing is saying, eliminating the last clause, and all they're saying is we don't identify names of living persons, but that's not what the test is. The statute says they have to show that disclosing their name would pose a substantial risk of harm to that person. And we are very, very concerned. We have made it very clear that it's really important for us to be able to know what people have information about the circumstances surrounding the assassination that have not been either interviewed in the past or known to the government, or whose testimonies not become public, because we need to talk to them before they die, because once they die, whatever information they have is lost to history. And this is one thing we've been battling over. And obviously the recent disclosures of Paul Landis from the Secret Service agent is just an example, whether you believe him or not. It's just an example of what a living person who has not previously had an opportunity to speak about something the kind of information they might have. Another important section of the statute for our lawsuit is Section 7. This is the powers of the Assassination Records Review Board. We have argued that the National Archives is the successor in function. They're the successor to the archive, to the ARB, and therefore they should have the same powers of the ARB. In fact, when the National Archives moved the ARB's regulations from the section of the federal code where it was previously into the National Archives section, they said in the Federal Register, which is the way that agencies publish regulations, is they publish the regulations in the Federal Register. And they said in the Federal Register to the American people that the National Archives is the successor in function to the ARB. And so we have argued that they should be doing the work of the ARB when the ARB went out of business. They didn't complete their work. They ran out of time. There were still outstanding search requests that had been posited to the CIA and other agencies that had not been completed yet. The Office of Naval Intelligence had not properly completed their certification of compliance with the Act. National Archives has been told on a number of occasions that there are reasons to believe that there are other assassination records that have not been found yet. So we have argued that the National Archives has failed to carry out its mandatory duties under the statute by seeking to complete the outstanding searches that were in effect in 1998 and to conduct new searches. And this is the Section 7 of the statute that we are using because it says this is what the ARB's power is. It's to direct the government office to make available and, if necessary, investigate the facts surrounding the assassination, additional information, records, or testimony from individuals where the review board has reason to believe is required to fulfill its functions and responsibilities. We're arguing you could substitute NARA for review board in this section. This is another section of a review of records. This is the where the review board in Section 9D 1 or 2, the review board would initially make a determination about whether a record is A, an assassination record, and B, whether it can be disclosed. If the agency disagreed with that, they would then appeal to the president. And the FBI was probably the worst offender in this area. They did actually file several appeals that were eventually resolved in the favor of the board. But this is the important thing here is the president shall have the sole and non-delegable authority to require disclosure. He can't punt to somebody else. And he has to use the standards in Section 6. Again, substitute review board for NARA because of the successor in function theory. So we are arguing that under this authority as well, that the president, well, first of all, NARA had to, was the one that would have to make these reviews. In fact, this is the process that's been followed after 2017. The agencies, NARA sends the agencies notice of an upcoming deadline. They provide information to NARA where they either agree to release information or they request further postponement. And then NARA makes a recommendation to the president, who the president can accept it or reject it. They're using this process that's here in the statute, and yet they're trying to argue that doesn't apply because the government's position is that Section 6 and Section 9 involved periodic review, and they've come up with a construct that periodic review ended on October 26th, 2017. If you'll notice, if we go back for a second to Section 6, there's nothing in Section 6 that says it's time limited. Doesn't say, until 25 years from the statute. It's open-ended. So the government's arguing that Section 6, however, terminated, and Section 9 terminated on October 26, 2017, the 25th anniversary of the statute. So the other interesting and important part of the statute is section 11. It says that the statute takes precedent over any other law, judicial decision, or even common law doctrine that would prohibit disclosure. So this is a super statute. It supersedes any other precedent. In other words, it supersedes executive orders. It supersedes case law that may have allowed for a record that's unrelated to the JFK Act to have been withheld. The government is not allowed to use those prior cases. This statute takes precedence, except for the one IRS requirement, which allows the withholding of Oswald's tax records. And you'll see Freedom of Information Act, B, nothing in this act shall be construed to eliminate or limit any right to file requests under FOIA. So it's preserving FOIA actions, although FOIA is actually it's still an inefficient tool. And in fact, one of the things we're arguing is that the National Archives policy at this point is that when a requester asks for records in the collection, they look to the index. If it's not in the index, they then tell the requester to use FOIA, which is completely contrary to what the statute provides. The reason the statute was passed was because FOIA wasn't working because of the exceptions. In fact, there's a lessons learned memo from the CIA from 1999 that concedes that the JFK Act would require disclosure under circumstances where the Freedom of Information Act would allow the record to be postponed or withheld. So part of the litigation that we're involved with is that we want NARA to do a different procedure, which we'll talk about shortly. Let's see. I don't know why this is here. I think I repeated this. Yeah. Okay. So these are the executive memos that President Trump and President Biden issued that postponed the release of assassination records after the statutory deadline. President Trump initially did a 6-month postponement, and then on April 26th, he did a postponement for 3.5 years. Biden's first memo postponed the records for a year on the grounds that because of COVID. And then on December 15th, 2022, he further issued a memo that used some terms that are not in the statute. So substantial weight should be accorded to the public interest. There's no such term, substantial weight, in the statute. He used the phrase anticipated harm, which is not correct because the harm is the identifiable harm. So the 3 Biden orders are the 3 orders that are subject to our lawsuit. So we have 5 counts in our complaint. The first count is that President Biden acted ultra vires. In other words, he acted beyond his authority by postponing records using criteria that were in violation of the JFK Act. Now, when you go after an administrative agency, you generally have to go under the Administrative Procedures Act. But the president has been determined by the Supreme Court to not be an agency for purposes of the Administrative Procedures Act. So we had to rely on a common law concept of ultra vires, which actually has its origins in British law. I'm not sure if I can say British or English, but anyway, UK law, where an officer of the government can't act beyond their authority, and that was carried over into the states. And so we argue that he just can't act. He's acting in excess of his authority by using conditions or standards for postponing the records that are not in the statute. Now, the president can always add conditions, but they have to be at least as stringent. They can't be less stringent. And as a result of that, we asked for mandamus against the president. In other words, an order against the president in essentially enjoining or preventing his orders from going into effect. It's hard to order the president to do something. The courts are very loath to do that, but you can enjoin the act, the order from of going forward. Now, that happened a lot in the Trump administration. But before the Trump administration, the most famous one was the one with President Truman, when he tried to shut down take over the steel mills during the Korean War. And that order was ruled to be against he didn't have the power to do that. And then we sued NARA as successor in function of NARA, and saying that it acted arbitrarily and capriciously in failing to carry out its mandatory obligations under the Act, under the Administrative Procedures Act, in violation of the Administrative Procedures Act for failing to carry out its mandatory obligations under the JFK Records Act, and that its approval of transparency plans and implementation of the Biden memos was also arbitrary and capricious or unlawful. Then we also sought a mandamus. This one was a positive or affirmative order, asking the court to order NARA as successor in function to the ARB to complete the outstanding record searches from 1998 and to conduct new searches. We also added a count for federal records violations when it appeared that records were missing, destroyed, or removed from the collection. The ARB could have requested the assistance of the Department of Justice, and NARA, as the successor, could do that. Now, there was an incident where Walter Sheridan, who was Bobby Kennedy's right-hand man, had deposited his records with the JFK library. And then when the ARB found out about these records, they asked for the records. And instead of turning them over, Sheridan had the records sent to NBC in New York. And he had worked for NBC in connection with doing a white paper on the Garrison investigation. And we don't know what his records contain, but the ARB actually sued NBC and the estate of Walter Sheridan, because he subsequently had died, for these records, and they were in the process of litigating this when the ARB went out of business. And there's been no follow-up on that. So NBC not only has the Walter Sheridan records, they also have, I think it's a Darnell film that many people believe could be, if it had the chance to be enhanced, they could determine whether Oswald was in fact standing in the hallway of the doorway of the 6th floor. So we have a major media company withholding what have been characterized as assassination records. Now, they claim a copyright, and yes, there could be copyright issues, but that would only mean that in order to get the records, the government might have to pay for the infringement on the copyright, but it doesn't mean that we can get those records. So these are the counts that we have in our complaint, and then we're seeking both declaratory relief and injunctive relief. So the declaratory relief is that for the court to rule that the memo violates the JFK Records Act, that the president acted ultra vires, and then the relief we would be seeking is compelling Biden to provide explanation, either have the memos enjoined from operation, or require the president to make the statutory requirement of identifying the harm for each record postponed and explain how that identifiable harm is outweighed or outweighs the public interest. and then compelling NARA to complete the outstanding record searches. And the other, and also a very important thing to researchers is we are also want NARA to put all their records online and correct. The records are a mess, those that are online in the collection. So we want them to make it easily accessible for researchers. So in terms of, let me go through the order. This is the December 15th order, and you'll see that I'm just highlighting, this is just the cover page, the bottom line, with the strongest possible reasons counsel otherwise. That's not a statutory term. I mean, they use terms here that are not in the statute, and yet they're claiming that they comply with the law. Section 6 of this act, of this order, provided that there were two categories of records that were to be that were subject to the order. Records in Section 2C, the president concluded would be released in the future pursuant to transparency plans that have been approved been developed by the agencies whose records are being postponed and have been approved by the National Archives. Then there were Section 2D records, which the agencies were supposed to do further work on between December of 22 and June 30th of 2023 to determine whether these records could be released or not. And they would work with the National Archives. Now, there was a couple of record dumps in June, which are pursuant to the 2D process. But then once June 30th rolled around, whatever records remain withheld are now subject to transparency plans. And you'll see under Section 6 here, the very last, at the bottom of the page, there's a reference to according substantial weight to the public interest. Again, that's not what the statute says. So we have terms in these orders that don't comply with the statute. Section 7 is the transparency plans. These are really anything but transparency plans. So the transparency plans provide that the agents for records that are not released by June 30th, 2023, or those records that were already determined not to be releasable on December 15th, 2022, the condition under which those records would be released were set forth in transparency plans, which are based on events or circumstances that would trigger a risk assessment. That's not an automatic disclosure. It's a risk assessment. Once the event or circumstance occurs, the agency whose record it is would then consult with the National Declassification Center, which is a body of NARA, and they will make a decision about whether the record could be released. No role for the president. And in preparing the transparency plans, all the agencies had the same line. You'll see at the arrow there, what remains redacted in the documents in this collection are not related to the assassination itself, but rather are primarily post-assassination documents and the details which remain classified concern intelligence sources and methods of current relevance. So even though the ARB said these records were assassination records, it's as if each of the agencies now are relitigating that issue and saying they're really not assassination records. They're after the assassination, therefore they're not, they should never have been subject to the JFK Act. And again, this is the CIA, not relevant to the assassination. Adds nothing to the understanding of President Kennedy's assassination or the subsequent investigation. Therefore, conversely, there is a strong national security interest in the continued protection of these identities of these individuals. And it says it here again, this is about living people. Human assets and sources. Similarly, it is vital that the unreleased identities of CIA's intelligence assets and news sources contained in JFK remain protected. Human assets and sources are the bedrock of the CIA's clandestine intelligence collection mission and the continued confidentiality of human sources and assets, regardless of age of the information or whether the individual deceased is critical to CIA's intelligence mission. Such information must be protected, both in order to protect the specific named individuals and their families from any harm, which they may be subject to. The statute doesn't say maybe, it says they have to be under substantial risk, as well as to ensure that more broadly, CIA will be able to continue to recruit vital assets and sources in the future. If current or prospective or sources or assets learn the CIA was required to reveal identifying information, despite the CIA's assurances of confidentiality, such individual likely refuse to work with the CIA. So this is how they're trying to argue around the statutory requirements. And again, no bearing on the assassination. So the transparency plans set forth in Section 7 don't, as you see, there's no role for the president. This is between a National Declassification Center and the agency whose record it is. Remember that the statute says the president has a sole and non-delegable duty. But this is what the transparency plans do. And they use less stringent, non-statutory criteria for grounds for continuing postponement. Several of the event-based conditions are not required with Section 6, 2, and 3. And we just went over that. This is the requirement that, they're saying they won't reveal names till people die. And if they don't know if the person is alive, they use the 100-year rule, which is 100 years from the person's date of birth. So whereas the statute requires the names may not be withheld unless they would pose a substantial risk of harm to that person. The Department of Defense goes further and says that for the strategic partners, if there's a document relating to the strategic partners of our government, and the records won't be released until they approve disclosure or the end of the partnership. What's the partnership? What kind of strategic partnerships are we talking about? Think of NATO. So if France or one of the NATO countries has an assassination record and they don't want to release it, we can't release it until they either approve it or NATO comes to an end, which don't see that happening anytime soon. These are not statutory requirements. And here's the CIA, is an example of the CIA's transparency plan. You can see where this is where the 100-year rule is, up in the first category. And you'll see in the second category, some of these records are going to be withheld as long as December 2024. Well, that's not so bad, but December 16, 2042. This Department of Defense transparency plans. And they have, you'll see the agency has to make the decision, and most of these, they're identifying intelligence sources or facilitate identification sources. And this is the legend for Department of Defense. So number 2 is from the date the DoD partners either approve release of their information within the JFK records, or the U.S. is no longer partners with that nation, or they have a diplomatic relationship that's formally dissolved. And then number 5 is the death of a person or 100 years. So that, so the transparency plans are really secrecy plans. Now, so we filed our lawsuit in October of 2022, and we then had to amend it in January because President Biden issued his December 2022 order. And the government immediately issued a motion to dismiss our complaint. We also filed a motion for injunctive relief. And we had the whole spring last year was spent, Bill and I was spent briefing both the motion to dismiss by the government and our injunctive relief motion. Motion to dismiss is to basically make the lawsuit go away. So the court ruled in June, the court struck down the counts against President Biden, so counts 1 and 2. The court also ruled that the National Archives was not the successor in function. But there's 2 remaining counts left: the Federal Records Act, and then some further work about the National Archives. So we have, interestingly, when the judge issued the motion to dismiss, his first paragraph said that, in summarizing the investigation work done by the Warren Commission, the House Select Assassinations Committee, he said that the government investigations concluded that Oswald was the sole culprit, which is not what the House Select Assassinations Committee said. So we have filed a motion to amend our complaint again. The government consented to that. And in that motion, in that amended complaint, we've added some additional facts that we did not have at the time the complaint was filed. And we've also admonished the judge for not understanding what the House Select Assassinations Committee said. The government is going to file a motion to dismiss the remaining counts. We are currently in settlement discussions with the government to see whether some of the issues that remain, if we can narrow the issues to the satisfaction of our client, Mary Farrell, and the 2, Ting Thompson and Gary Aguilar. In any event, even if the judge knocks out the rest of the counts, we can always appeal to the Ninth Circuit. And the Ninth Circuit has a history. So we're in the trial court, the Northern District of California. When all the counts are resolved, or if the parties settle, but when all the claims have been, a decision has been rendered, then we can then appeal to the Ninth Circuit and revisit some of the issues. We believe the judge made an error in a number of circumstances. We do believe that under case law that President Biden, he seemed to think the president had extraordinary discretion under the act. He does not. He doesn't have unfettered discretion like in many statutes. He has to make specific findings. And even though he can only do what Congress authorized him to do. He was given the ability under the statute to make certifications for final postponements using criteria set by Congress. There's very little wiggle room there. And yet the court found the president had extensive discretion, and therefore, courts are loath to tell the president what to do. But he felt in this case that the president acted within his discretion. He also said the president is free to make new, different standards in the act, but what he didn't say is they have to be at least as stringent as the act. And then, obviously, we disagree very vehemently with the fact that the National Archives is not the successor in function because they said they were. I mean, how do you? It's just, and they were claiming that they were. They didn't really mean what they said. So, we are we'll be filing a motion soon, another motion, and I suppose the government next month will probably file its motion to dismiss the remaining counts. Everything's on hold right now, though, while we have our discussions about whether there are mechanisms that we could, or some sort of things we can agree on to settle some of the issues. Like, for example, a very big issue I know to Rex is to have the records digitized. And, they may commit to do digitation maybe at a faster rate than they would normally do. And that might take away the central index count or claim in the statute. So I think I don't know how much time I have left. I think I can
Well,
take.
that's a great update. I think we are running a little bit out of time.
Okay, so I can take some questions, or we
Yeah.
can just end here.
Let's just see if there are any questions from the floor, Larry. One second.
Larry, Paul Bloat here.
Hey,
Hey, how you doing? You know, when I went through the most recent dumps, one in June and the one in August of, and I mean, it seems that there's almost nothing or less than 5% of what is being dumped in the most recent releases that, you know, that represented any potential risk to harm. It may have been a bit embarrassing, some of the stuff. Do you use any of that, like saying, hey, listen, you know, what we're seeing in what you are releasing, you're obviously abusing of, you know, of the power that you do have. I don't know if you understand my question or.
yes, I think you're saying that when they release the records, you look at them and say, well, where was identifiable harm?
Yeah.
Right. Yeah. That's something that we've been talking with them. But you know, the National Archives doesn't. They don't really have declassification power. This is a problem with the agencies. This is a problem that is throughout our government. There's a problem of overclassification, and the fact that, you know, the harm that is allegedly caused these records to be not released is certainly something that, you know, when we appeal, which we are probably going to appeal, those are the kind of things we're going to, you know, appeal on. It shows you that they're really not complying with the statute. There really wasn't any real harm. But, you know, honestly, it's not the records in the collection that I'm really interested in about. It's the records that are not in the collection that should have been put in the collection. And things like, you know, the Carlos Marcello tapes from the when he was in jail and Jack Van Langenham was his cellmate. Those tapes have been sealed, and they're held by the court in the Fifth Circuit, and we're asking for those records because we don't even have transcripts of what Carlos Marcello said. Supposedly he confessed to killing the president, or at least you know, plotting to kill the president. So we're interested also in the records that are not in the collection, because we don't, you know, and by the way, the procedure that we're asking to have is we're going to either ask by rulemaking or by some sort of settlement that instead of telling the researcher when they don't find it in the collection to go use FOIA, we want to do is have NARA then contact the agency whose record it is and say, do you have this record? If they say yes, then we have to see if it's an assassination record. If it's yes, then we have to decide if it can be disclosed. And then that information then is given to the researcher as a tentative decision. And the researcher can accept that, or then at that point, do administrative appeal. So we want to set up a process so that the burden isn't on the researcher to use the Freedom of Information Act, which is probably not going to result in any significant records being released.
Thank you.
Are income tax records, would they be included in this, or are there different rules for income tax returns?
Yeah, Congress, in the statute, Congress exempted the income tax records. Now, there is a bill that was released in January by a congressperson from Arizona that would eliminate all of the exemptions under the statute, not only the tax records, but also the limitations on the deeds of gifts, so that we could get the William Manchester tapes of Robert Kennedy and Jackie Kennedy that have been also withheld. But that if that statute was ever passed, it would eliminate the IRS restriction. But right now it's still in effect. We can't do anything to get those records, either by a lawsuit or by arm twisting.
Okay, Larry, that's great. Unfortunately, we're running out of time as well, so I think we can't ask any more questions, but
Okay, well, if anyone has questions, email me and I'll be happy to answer them.
okay, that's great. Well, I'll make sure.